Welcome everyone to this new edition of the ICONES New Scholarship Showcase Authors Book Interview. Today we have the pleasure and the honor to interview Professor Aileen Kavanagh, who is a Professor of Constitutional Governance at Trinity College, Dublin. And she is the author of a very important book in the field of comparative constitutional law, The Collaborative Constitution, published by Cambridge University Press in 2023. This is an absolutely important book in our field because Professor Kavanagh is challenging some of the most relevant tensions that we are experiencing in the field of comparative law, and especially with regard to the separation of powers between the three classical branches, the legislature, the executive, and the judiciary. And she is challenging us to rethink to the relationship between the three branches in a more collaborative way. So, Professor Kavanagh, can you tell us something more about your book? What inspired you to start this project?
Well, thank you, Antonia, and to iConnect for engaging in this conversation and focus on my book. I'm very grateful. So what motivated the book were a number of different thoughts that I had. The first was a view that I had held over many years, which was that the big debates between legal and political constitutionalism, between this idea that judges only should adjudicate constitutional issues or protect rights, or on the other hand, that legislatures should reign supreme. My sense over many years was that this debate, this binary framing, this oppositional dynamic between courts and legislatures was simply not capturing the complexity of constitutional dynamics on the ground. It wasn't either or, all or nothing, and it wasn't a question, I thought, of whether legislatures or courts should have the last word or reign supreme. So in a sense, both that debate and the questions even that interlocutors in that debate were asking, I thought were distortive, wrong. And the other issue that came onto my horizon was at that same time, this is about 10 years ago now, there was a lot of scholarship in comparative constitutional law on the new Commonwealth model of constitutionalism. And here I'm thinking of Stephen Gardbaum's influential work, but also Mark Tushnet writing about weak form review and dialogue, and Ross Dixon was part of that as well. Now, I thought this made an advance in the field. It was a paradigm shift. It was acknowledging that we could maybe imagine interaction between the branches. But again, when I looked closely, I thought that these theories of weak form review, dialogue, Commonwealth constitutionalism, again, my view was that they were not capturing the practical dynamics on the ground, nor were they making normative arguments that sat well with me. So the kind of arguments from a dialogic position that would say, well, legislatures should override courts and courts should adjudicate robustly on the merits without any inhibition. These seemed problematic, deeply problematic to me. So the idea of the collaborative constitution then was to work in this middle ground, so between legislative supremacy and judicial supremacy, but try to articulate an empirically more satisfactory account and one which grounded normative arguments which seemed more satisfactory to me, more desirable. So working within this middle ground of trying to reconcile constitutionalism and democracy, I came up with the argument that we should view constitutional government not as an either or, and not as a cozy conversation between friends either, but rather as the hard work of a collaborative relationship between partners where they each perform a distinct role whilst working together. And in a way, the book is a matter of stepping out what that working together looks like.
Yes, indeed. In your book, you make a call to overcome the Manichaean view of the legislator-judiciary dichotomy. And so can you tell us more about this concept and also the differences with other non-conflictual understandings of the separation of power, like dialogue, because we're used to apply the concept of judicial dialogue, which is also a not conflictual concept in order to explain the relationship between the legislator and the judiciary.
Wonderful. Thanks, Antonia. This is a great question. So first of all, on the Manichaean narrative. So I do have, in the first chapter of the book, I have a look at this rivalrous, dichotomous understanding, which I describe as a Manichaean narrative. And I have a little bit of fun with this, you know, the rivalry between good and evil. But I also rely on direct quotation, and there is a real sense in that debate that, if you like, those who defend judges present them as pure as the driven snow, and the legislature is the enemy, and vice versa. So Adrian Vermeule has described this as the nirvana fallacy. You paint your own side as white and damn your enemy black. This is one problematic aspect of a polarized debate. Okay, so we move forward then, and I'm arguing and defending the collaborative constitution. So first of all, I say, in the collaborative constitution, it's not a matter of pure virtue against black vice. It's a matter of each branch of government having partial virtues, pros and cons, and we have to look clearly at those mixed virtues and vices in any institution. All institutions are imperfect. We have to face that head on. Second of all, in the collaborative constitution, I argue that each branch has a distinct role. So they're not all engaged in a rivalry for supremacy or, you know, trying to rule the roost completely, but rather that they each make a contribution. And part of the book is working out what exactly is that contribution? What are the role conceptions which attach to each branch of government? So it's a kind of grounded, bottom-up analysis of institutional roles and relationships. The key feature, I suppose, of the collaborative constitution is that I say that all branches are embedded in a long-term working relationship. And that very fact, the fact that they're embedded in this working relationship, shapes and constrains the interaction between them. If you and I are working together, Antonia, on a project, then we have norms of engagement. We must respect each other's contribution, acknowledge that we're both different, bringing different skills to the table. And also then there are modes of respect. Sometimes we have to bite our tongue. We have to hold back. We have to exercise some self-restraint. And so I say it is at the level of constitutional government. So that brings me then to your question, well, what's the difference between this dialogue? And I thought it was really interesting that you said, well, that dialogue is also a non-conflictual understanding. And what's interesting when you look at the dialogue scholarship is that certainly the idea of dialogue sounds cozy, sounds friendly, you know, we have a chat, we have a conversation, that sounds very nice, mutual respect and so on. But in the dialogue scholarship, it was not long before the dialogue theories took on a conflictual dynamic. So they would say, well, instead of the courts having the last word, the legislature should have the last word, and the legislature should override the courts. That's the only way we get kind of democratic constitutionalism. And so quickly what occurred was a kind of, instead of the courts having the last word over the legislature, it was vice versa. And so why is that? Why is that in the dialogue scholarship it became a kind of conflictual? In fact, I argue it resurrected the Manichaean narrative. Well, I think the reason is that the metaphor of dialogue was too shallow to distinguish between different types of relationship. And, you know, in the collaborative constitution, you might agree or disagree with it, but it makes a definite argument about the nature of the relationship between the branches. By saying it's collaborative, I'm not saying it's cozy. I'm not saying at all that they need to agree or all be on the one side. That, in fact, would be damning for constitutional democracy, where we need robust checks and balances. We need some grit in the system. We need branches of government to be able to say to each other, you have violated a constitutional norm. However, those disagreements, I argue, are framed within and should be framed within a kind of collaborative relationship where they must nonetheless treat each other with respect. And also, at times, hold back, exercise self-restraint. Now, the theme of self-restraint, which runs throughout the book, and I argue all the branches must exercise some moderation in a way, that was not a leitmotif of the dialogue scholarship. In the dialogue scholarship, they tended, naturally enough, to emphasize outspokenness, the discursive values. Judges should speak their minds. The legislatures should override if they disagree. I find this a kind of naive and somewhat abstracted account of constitutional government. So I ground my account in what the branches of government actually do. You know, I have a line in the book where I say, well, talk is cheap, but collaboration is hard work. And that captures something. In other words, you know, we can talk to strangers on the street. I can talk to you. We can talk to our partners. There's a big range of contexts here. But collaboration, to work together with others in a partnership, that is hard. That places onerous normative demands on those who are party to the collaboration. And in a way, in the book, I step out those normative demands, which are various. It's not just, I am in no way saying to the branches, you all speak out. No, I'm saying sometimes you need to speak up and sometimes you need to keep quiet. And so it's a more variegated normative landscape that I'm trying to capture.
Wonderful. And as I said, this is really a groundbreaking book, and it's going to open new perspectives in the field of comparative law. So what are the new perspectives that you think your book can open in the field and also in the literature about the separation of powers?
Right. Well, what I'm hoping is that in a way, this book might shine a light on interactive, relational, and of course, collaborative conceptions of the separation of powers. That I think our understanding of the separation of powers as inherited to us from the time of Montesquieu and other kind of classical texts, it was almost like there was a corruption in the file. We have an emphasis on separation, on isolation between the branches. And what I'm trying to do in this book is to say, actually, we need to rethink the separation of powers as a dynamic process of engagement, as relational. And here I would, you know, I think of Marta Cartabia's editorial in Icon S, where she talked about courts relations. But I think more broadly, I think it's important to put relationships, interinstitutional relationships, at the heart of our understanding of the separation of powers. And obviously that sounds counterintuitive or contradictory. How can a doctrine that advocates separation of powers nonetheless ground a collaborative account? Well, I tried to resolve this apparent paradox in the book, and I say, well, you know, there are degrees of separation. And even if you and I are in a relationship, we can still have our own person, our own autonomy, our distinct roles. So really focusing on those collaborative dimensions of the separation of powers, I think that's an important direction. And I know that in ICON-S, there's a new interest group on the separation of powers, headed up by Michaela Heilbronner and Sergio Verduga and others. I think this is really important in rethinking the separation of powers. In terms of comparative law, I'm hoping that maybe the book might stimulate some collaborative analysis of discrete issues, say like assisted dying, abortion, same-sex marriage, and so on. The collaborative constitution is an account of what the branches are doing, and I think it has legs and resources on which other scholars might be able to draw to examine what all three branches of government, and by the way, other actors as well, what contribution they're making to resolving these issues. In constitutional law, we often quite naturally focus on the courts and the courts alone, or judicial decisions. This is a plea to pan out, to step back and look at the array of constitutional actors that contribute to the resolution of these issues, including, by the way, social movements and popular movements and the people in general. That wasn't a big theme in the collaborative constitution, but I see it as a theme going forward.
And thank you so much. And in part 3 of the book, you defend a collaborative conception of the judicial role, which you call judge as partner. Could you say a bit more about this idea of constitutional partnership and what it means for judicial decision making?
Thanks, Antonia. I'm happy in a way that you draw out this theme of judge as partners. So, as with all of the chapters, in a sense, I'm trying to step out what constitutional partnership means, and therefore maybe it's not surprising that I say, well, the role of the judge is in part to be a partner with the other branches. And what I have in mind there is that I'm saying no to the Dworkinian Herculean judge, the kind of judge as hero conception. But I'm also saying no to the idea of judges as enemies of the people, as democratic debilitators, and so on. I say, look, as with a lot in the book, it's somewhere in between. Judges have a meaningful constitutional role to uphold constitutional values, to protect rights, and so on. But I emphasize their institutional limits. They certainly can't go it alone. They are not the top dog in the constitutional scheme. They have what I call a significant but subsidiary role, and some of that part of the book steps out what subsidiarity means here. In that part of the book, I kind of canvass some of the tools that judges use, and I see this across many jurisdictions. There's a theme of judicial incrementalism. I look at canons of construction, like the clear statement rules in the United States, the principle of legality in the UK, Australia, and other Commonwealth countries. I also look at proportionality, the doctrine of proportionality, but what I'm emphasizing is that it is proportionality in partnership, that in a way, when judges are adjudicating whether a piece of legislation is proportionate, they're engaging with the legislature in significant ways. I suppose another core idea in that part of the book is the idea of calibrated constitutional review. So again, I wasn't advocating judicial activism, but nor was I saying, look, judges should be timid, judges should be restrained, judges should, not stick their head above the parapet. No, I wanted to articulate a kind of robust judicial role while simultaneously accounting for their limits. And what I came up with was this idea of calibrated constitutional review, where the courts have to, in every case, in fact, calibrate how much they will step in, how much they will step back, and when they stand firm. So kind of not being prescriptive about it in particular cases, but I delve into the anatomy of adjudication and try to uncover the calibrating factors involved. There's just one more point I would make on Judge's Partner, which is that, again, in the dialogue scholarship, there was a lot of emphasis on judges, if you like, responding to legislatures. And I think this is true to a large extent. But I also, in my book, emphasize the catalytic role of the court. So I talk about court as catalyst, judge as nudge, and I uncover some devices that judges use there to kind of nudge the political process forward, to incentivize the legislature to do their bit for the collaborative enterprise. So even when judges in some cases are saying, it is not up to us, we are not the appropriate branch of government, let's say, to legalize assisted suicide or whatever, they might nonetheless not be completely inert. They can push, they can nudge, they can catalyze constitutional action in the other branches.
This is a fascinating perspective, and I think it is super useful also for looking at the jurisdiction like the Italian one, the US one. So I think that it's so a new perspective that you open to look at the relationship between the branches of powers, and particularly on the role of judges in our constitutional democracy. And so writing a book is a kind of journey, which is a wonderful journey, but not always an easy one. So what are the difficulties that you encountered in writing the book?
Yeah, this is such a good question, and yeah, there's no way around it. It just was very difficult, partly because it was an ambitious project that, in a way, I had thought about many of these issues for a number of years, both in terms of doctrine, in terms of kind of concrete application, but also in terms of the big theoretical debates. And I wanted to address those big questions. And obviously, when you're working at the edge of your knowledge, this is challenging and this is difficult because you don't know where it's going to go. Then when I came up with my answer, my solution in a way, the collaborative constitution, the other challenges ensued. So one was, ironically, I felt this was right. I felt the idea was correct. I mean, that might be obvious, but just to say it, I felt it had deep explanatory power, but it was also generative of interesting normative arguments. And in a way, I wanted to do the idea justice. So I felt I had to do right by the idea, and therefore this felt like a responsibility. The other issue was that by virtue of saying it was a collaborative process between all three branches, and by the way, other actors as well, then I had to put my money where my mouth was. I had to step out what those other branches were doing. And that took me outside of my pre-existing, my kind of constitutional comfort zone. I had worked for many years on judicial reasoning, on the role of the courts, and we're all kind of experts in these legal devices. but I hadn't seriously looked at how the executive works, how the legislature works, and so on. So I had to read a lot of political science literature, political anthropology, even sociology. There was a big interdisciplinary challenge, and the project became larger, like not just broader, but deeper in many ways, and taking me into different subject areas. And I think that shows in the bibliography, which is very large because it spans across political theory, jurisprudence, political science, um, uh, legislative anthropology. I mean, there were lots of different. So that was challenging. Um, and then there was the sheer sense of scale, the challenge of scale and size and trying to make it manageable in a book, length format. Um, and then I suppose, when you ask me that question, Antonia, I have to say, well, there are challenges of law, but there are challenges of life, and trying to sustain constitutional scholarship of this scale over the long term, doing justice to an idea, engaging seriously with other scholars as well, and not just glibly, passing them by, but really giving my interlocutors, even those that I disagreed with, the best defense I could before engaging with them. Well, all this is challenging, and my children were young, younger, and you're trying to balance different competing concerns in life, and that was a challenge. So I do feel a kind of sense of completion now that it's done. But it was not easy, and maybe the most ambitious scholarship that we undertake for ourselves is just by definition not easy. It should be difficult. It must be difficult. But it certainly was difficult sustaining it over the long haul. Yeah.
Thank you very much, Aileen, because you are a model of inspiration for many scholars, especially, let me say, for women that are working and are trying to combine scholarship to catch up on the development of the field, and also combining with private life, children care. So thank you very much, because you show us that after a great book, there is a life ongoing. So I think it's quite reassuring also for young colleagues that are taking over their journey in the field. So let me ask you the last question about what is your next project now that you accomplished such a ambitious and super important book. Now, what's next?
Well, in a way, I'm kind of enjoying at the moment having done the book and doing smaller, more discrete projects that are also an outworking of the book, because if constitutional government is collaborative, as I argue, and I do think I'm making a deep argument there, then there is a sense in which all my future work, but certainly at the moment, is still working through some of the implications of the collaborative constitution. But so I have lots of nice discrete projects in that domain, also engaging in more comparative dimensions of the collaborative constitution. But there are two kind of interrelated themes that I want to pursue that I haven't so much in the book. And one is the role of the people in the collaborative constitution. So in a way, this book is about the separation of powers. It's about branches of government. It's about the interaction between institutions. And I don't say much about the role of the people, but I want, there are strands of thought about the nature of democracy, and I want to lift those up and substantiate them. I feel that as constitutional theorists and as comparative constitutional lawyers, this is the most important issue we face. What is democracy and how is it distinguished from populism? I want to write a piece which articulates those differences. And the second unrelated project is that I'm thinking about writing a book. So my next book, I think, would be on participatory constitutional change in Ireland. So there's fascinating stuff going on in Ireland in relation to referendums and the role of citizens' assembly in changing our constitution and in developing that sense of ownership that people have over their constitution, our constitution. So there are fascinating developments. Again, it goes directly to this issue. What is democracy? How is it different from populism? Some people describe referendums as mechanisms of direct democracy. And my sense is that, in fact, it's a mechanism of indirect democracy, or at least it is, in the Irish example, it's deeply embedded within broader structures of representative democracy. So in a way, those two projects could go together, the kind of theoretical understanding of democracy on the one hand, and then looking at democratic constitutionalism in action. You know, I do have a sense that obviously the theme of democracy is so prevalent in US constitutional law. But actually, the American people, if you could even talk about a singular people there, don't have much input into what their constitution says. Whereas in Ireland, there is that ongoing, not just generational, but nowadays, maybe every couple of years, we have another referendum, and we're having one now on the role of women and family and care. These are big debates, and I think that would be, not for now, you know, maybe in a year's time, I'll think about framing a book on that.
Wonderful. These are both very important topics. And I know that your book has already fostered debates about the role of democracy. I read Roberto Gargarella's comment on your book that was pushing you in going towards the direction of exploring the role of democracy in the collaborative constitution. So I think this is the test that your book is really groundbreaking. So it has opened a debate in the field and will have an impact on the field for the years ahead. Thank you very much, Aileen, for your interview and for your contribution and for being an inspiration for all of us. Thank you.
Well, thank you, Antonia. It's been brilliant to talk to you about it, and I look forward to future conversations.